Hi everyone, and welcome to Last Week Tonight. This is Arkady Frehktman. I'm a New York City personal injury trial attorney. And today we're going to be looking at your comments and answering your comments and your questions. Here's a question. It says, what exactly is a doctor's deposition after a hearing? Okay, so yeah, some states have doctor's depositions. So basically, let's say you have a personal injury case, right? Like a car crash. And then you have a doctor that's going to support the case to say that the injuries are caused by the crash and what the injuries are, that the injuries are serious, that you have this life-changing forever injury, and give you a diagnosis. Meanwhile, the defendants have their doctor that's going to examine you maybe like for 15 minutes and say, you know what, it's not caused by the crash. This is degenerative from living your life. And the injury is not that serious. You don't really have this injury. You had it before and nothing really happened from this crash. So what happens is the plaintiff's attorney then deposes that doctor, and then you could use the testimony to cross-examine that doctor at trial. And in the same way, the defense lawyer for the insurance company will question the plaintiff's doctor, the treating doctor, and then use that transcript to cross-examine the plaintiff's doctor at trial. So it's like mostly known as expert depositions. You have it in federal court. You have it in a lot of states. I believe like California has it. New York, we don't have it. We actually just, when I cross-examine an independent medical examiner, like a defense doctor, I'm confined to the report. I do get a report. Usually it's like 2-3 pages. So I have to cross-examine him or her based on the report. I don't get a deposition in New York State court. And then in terms of how long after, well, depositions of doctors are probably one of the final discovery things that you have to do. So if you're at that stage, that means you're getting closer to the end of discovery, which means that most likely it'll go on the trial calendar and the case might settle, or you may get a trial coming up pretty soon. Here's a question. Does a medical malpractice trial happen in the area of where the mistake happened? Or if it's a large hospital with multiple locations, can the location be picked for trial? So yeah, that depends on where you are, like what state, because each state has their own rules about venue. In New York, where I practice, the way it works is if you're suing a private defendant, it's based either where one of the parties resides or where the incident happened. So in an incident like that, it would be either where the plaintiff lives, where the corporation is incorporated, like if you're suing a hospital and it's a corporation, it's where they are incorporated. It wouldn't be like every location if they have multiple locations, that wouldn't matter, but where the company is incorporated. Or it could also be like if you're suing a doctor, where the doctor resides, or it could also be in many cases like in car accidents or in trip and falls, it would be where the incident happened. So you have a choice. For example, if I live in Queens as a plaintiff, but then I went to a hospital in Manhattan, and then one of the doctors may live in Westchester, I could choose any one of those, right? So that's usually how it works for venue. Here's a question or a comment from OG X-Ray 22. I had a slip and fall in February, and it caused 3 bulging discs. I have been doing physical therapy. I had a few chiropractic sessions and 2 steroid injections, and the pain is still there. I'm becoming depressed, just in constant irritating pain. Yeah, I'm sorry to hear that. I mean, that's terrible. What you would want to do with something like that is you'd want to make sure that you have the liability as strong as possible, meaning, okay, you had a slip and fall, but what caused you to fall? Was there a dangerous condition? Like, was it a crack or a hole in the ground? Was it a transient condition such as water or oil or like a, banana peel? So you want to know what it was and whether you can establish liability through notice. You have to prove notice. And then the fact that you have these injuries and you've been doing injections and therapy, that's good. Make sure you continue with the therapy. And also, if the therapy is not helping, you may need to see a specialist, go that next step and see like a specialist, like an orthopedic surgeon or a pain management doctor for the injections, and or even a psychologist if there's issues with depression. And make sure you have a real trial lawyer handling the case, because a trial lawyer is going to know how to develop that case so you get the maximum result. And here's a question, come along with Uncle Joe says, Los Angeles, California, trip and fall, very good liability, torn labrum, torn rotator cuff, 3 shots for steroids in the shoulder, 2 surgeries, and over 100 physical therapy visits. The value for that only, please and thank you. Yeah, well, it's hard for me to say value, exactly. We could do verdict searches in Los Angeles and see what similar cases go for. But based on my experience, I'm mostly basing it on New York, where I've handled cases. But I think California is, from what I've seen, relatively similar, maybe even in some cases higher. Trip and fall, when you say good liability, we'd want to know what happened, what are the actual facts, but I'll assume it was very strong against the defendant. But yeah, something like that, torn rotator cuff with surgery, we'd have to see what kind of surgery. If it's an arthroscopic surgery, those are worth, I've settled those cases for $300,000, $400,000. If it's more with anchors and more involved surgery, I've even had those go for closer to $1 million, $875,000, $850,000. So, and then you have a lot of physical therapy, so that shows that it's a serious injury. It's not something that's going to go away. So it should be a large amount. It could even be $1 million case. And then Mr. Carter says, is a mediation listed on the court docket or just the settlement conference? My docket says listed for settlement conference, but I'm unable to reach my attorney. It's been a few weeks. Yeah, so usually with mediations, unless it's court ordered. If it's court ordered, then it would be on the court docket because it's court ordered. But usually what happens is the plaintiff's attorney and the defense attorney agree on a judge and they just do a private mediation. So you'll just come to their office, for example, NAM or JAMS or any of the companies. You'll show up to their office. You'll know when it's set for. The plaintiff can come as well, the client, and your attorney will prepare a mediation brief, and then they'll just negotiate the case. They'll present the case and talk about everything, and they'll say, look, we think the case is worth $1 million for X, Y, and Z reasons. And then they'll say, well, we think that our offer is only $100,000. And then they'll see if they can bridge the gap and come to a middle ground where both sides agree. And if they can, then it's settled. And if they cannot, it's non-binding. So then you just go to trial. So it's an attempt to settle. But I've seen some mediations take the whole day. People show up 8 a.m. and they're there until 5 p.m. But then by the end of the day, they really bridge the gap and they come to a settlement. So it definitely can be a fruitful exercise. As I've said before, you want to make sure that there's a good faith offer and that the other side is going to negotiate in good faith, because you don't want to show up and think, hey, I have $1 million case, just for them to give you $5,000 and laugh at you. Then it's all a waste of time. So you want to make sure that it's a real, it's going to lead to something, lead to some kind of resolution. And here's a question from Alberto. He says, hi, Arkady. Every single case is different because the case happened in Queens, August of 22, and settled May of 24 for 1.2 million. This is less than 2 years they settled. So this is the lawyer doing a good job. The insurance company is very good at resolving it fast. My point is, I think the case was very fast, everything in the case. Yeah, if you do things, quickly, if you get experts, you have to think ahead, right? You don't want to just file the lawsuit and think okay, I filed the lawsuit, let's see what happens. You want to make sure, okay, I have let's say a trip and fall. How am I going to prove liability? Who are the witnesses? Talk to the witnesses, get statements from them, get affidavits. You could even take non-party depositions once you file the lawsuit, right? Get everything early. Have everything ready, all the medical records, authorizations, allowing the defendants to get medicals. So when they ask you, hey, can I have your medical record? Yeah, here it is, same day. Why wait, right? Things get delayed sometimes just because lawyers sitting there and they're busy and they have a lot of cases. And the defense lawyer or the insurance company might say, okay, give me an authorization for that surgery that you had. And then the paralegal might send the authorization 3-4 months later. Remember, it's just an authorization, right? So now they've gotten it 3 months later. It's a piece of paper. Now they have to send it to the doctor and hope that the doctor's secretary in there is going to process that authorization, copy the medical records, and then email or snail mail those medical records to the insurance company and the defense lawyer. What if they don't, right? So anywhere in the chain, things could slow down, and then the case starts taking 5 years. So you want to make sure you're very proactive and you think of everything ahead of time, especially liability, because that's something you have to prove, hiring experts, taking measurements, photos. The more evidence you have, the better. You want to make your case as strong as possible. Okay, here's a question from Redskin Bears. At 36 years old, I have been treated for back pain from 2004 to 2009 with pain medication, no MRIs or x-rays. After the market crashed in 2008, I did not work for a couple of years, but was able to continue my pain meds until I regained enough hours to return in 2013. They did x-rays and said that I had spondylosis with a part defect, but it was congenital and didn't file workers' comp. Then they changed my diagnosis to lumbar radiculopathy. I had a fusion, L4-S1, and 10 years later, I'm having problems with my neck, my cervical, C4-C7, and I was never told anything about adjacent segment disorder. In 2021, I was told it's a pinched nerve, myofascial pain syndrome, so I returned to work only to further damage myself, and the next MRI was done in 23, showing a worsening condition. So I left to get a second opinion, and the neurosurgeon says that now I need a fusion C4 to C7. Yeah, that's pretty serious. I mean, it also goes to show, you see, like sometimes doctors aren't sure, like different doctors can give you different diagnoses. Nothing is like an exact science. So, but yeah, it sounds like it's just definitely a serious injury. I'm not sure, it sounds from the comment like it might be a workers' comp type case. So with workers' comp, you're entitled to lost wages as well as all your medical bills being paid, but that's money that goes to the doctors. But you're also sometimes entitled to money for yourself, like a Section 32 settlement in New York. But yeah, I mean, think about that, see if it makes sense to do that. You definitely get like a second opinion, but it sounds like it's a serious injury, definitely. Serious life-changing injury. Here's a comment to the video. How much can I obtain for pain and suffering at trial? What is my case worth? And someone says, what about a loss of life? A life had to be taken because of such bad neglect at 71. Yeah, that could be a very large case because you're talking about wrongful death. So in New York, we actually are, hopefully we're gonna get that loss of love component to wrongful death. Right now, it's only the monetary damages, right? So if you have, let's say, somebody who gets wrongfully killed, like a pedestrian in the crosswalk and he was a father, you can't sue for like loss of love. You could only really sue for loss of parental guidance, the children, and then you sue for the pecuniary loss, which is like the paycheck losses. But you can't sue for loss of love, which a lot of other states do have that. So hopefully they change the law. There's a bill pending with the Grieving Families Act, and then we should be able to sue for that as well, which, you know, should be the case. But yeah, generally those could be very large cases. Those could be multi-million-dollar cases. Charles says, unless the defendant is carrying $1 million policy, why proceed with all this prior nonsense if the insurance company is responsible only for the maximum? On the other hand, if the defendant has any assets, that would be another story. Yeah, so usually what we like to do is find out, right, all the policies. So there's the primary policy, which might be like $250 or $300. Then there could be excess or umbrella beyond that for another, $500. We have to find out. Once we find out, we have to also evaluate the injury, see what the injury is worth, and then go for the maximum. So that's usually what we try to do. The prior stuff is something that they say, right? They say, well, it's not caused by this incident, it's caused by living your life or some prior, like pre-existing condition. That's something that they say. It's their standard arguments. We just have to address that. All right, thank you for joining us here. We love answering your questions and talking about your comments. Please like and subscribe to our channel and let us know what questions you have or what topics you want to see for future videos. We're happy to do that. And if you need a consultation, just text me. It's 347-566-9595. Just text me the facts of what happened, your injury information, the date of incident, and your city, as well as maybe like your first name. And then we can just schedule a call, and I'm happy to give you some insight and provide a free consultation. Okay, have a great day, everyone.